Good afternoon, everyone. Welcome to webinar 2. So today we're going to cover some topics that are more around IP strategy and sort of things that you can think about as you're going along in your work, and no matter what stage you are in your business, and also some sort of more practical tips on several different areas. So first of all, we're going to recap or what we covered in webinar 1. So that was IP fundamentals, IP basics. We'll give a brief recap of that. We'll then go on to talking about certain questions that you can ask and tips on how to identify patentable inventions in your work. We'll then talk about patent drafting, specifically in this field, and strategies that we normally use to sort of obtain the scope of protection that is sort of most commercially useful for you, but also sort of aim to progress the application to grant. And there's certain tips that we can share when drafting a patent application in this field. We'll then talk about ownership, so common IP ownership and collaboration pitfalls. And after that, there'll be some slides and some conversation around patent searching and techniques around patent landscaping and the differences between those two techniques and how you can use them. And then we'll end by giving sort of, I think, 4 key practical IP tips for startups in the area of AI materials. We'll talk a bit at the end about how Keltie can help as well in different areas that we can help with. So a brief recap of the first webinar. So we talked a bit about applications of AI-driven materials, the applications across a range of sectors. So we're seeing a lot of applications in sustainable materials, medical technologies, as well as sort of renewable energy and that sort of thing. We covered types of IP rights and using patents as commercial tools. So as a brief recap, the main IP rights that we talked about were patents, registered designs, and trademarks. And then we covered a bit about AI-driven approaches in materials discovery and what that means. So there was a little bit about property prediction and inverse design, and then actually designing new materials using AI-driven methods. What inventions can be patented? So one of the key things in terms of what needs to be done in order for an invention to be patented is that it has to be novel. Secondly, it has to be inventive, and particularly for software inventions and mathematical methods, it has to provide a technical solution to a technical problem. And we then looked at some real-world examples of patentable technologies, and finally we talked about the patent process. So if you have any questions on any of that, we can cover that at the end or in a follow-up. But moving on to the first topic of the second webinar. So we've got about 6 key points on certain things you can do as you're going along in your work and your research in order to try to identify patentable inventions. And so the first one is sort of key questions that you can ask early and often as you're going through. One of the key questions is what technical problem we're trying to solve, because with patentable inventions, we're always trying to look for a technical problem that we're solving and providing a solution to that problem. And that will put you in a good place to sort of when it comes to filing an application, framing it in that way is often quite beneficial in progressing the application. So what technical problem are we trying to solve? What's new compared to known methods and known materials? And did we change how something is made, controlled, or optimized? So what exactly was changed, but did we change how it was done? And if there's something new and sort of advantageous that provides a technical solution over known methods and systems, then you may have something that's patentable. Number 2 on the side is look beyond the model, look beyond the AI model. So look at what new material compositions or structures are being formed, improved synthesis or processing conditions, control, if there are any sort of improvements around the control of experiments or manufacturing methods. Also, this last point might not always be considered, but it's important to sort of take a look at it and consider it, because it's in the data where you can often find patentable inventions in how the data is processed. So in data generation, selection, or validation. Another example is in data cleansing, for example. If there's something new or new and advantageous about how the data is being processed, then there may be something patentable there. So it's important to explore all of those things, explore the materials, explore the methods, as well as the AI models. But the third point here is capture inventions as you go. So record failed attempts as well as successful attempts and unexpected technical effects. Document decision points where AI output changed actions, and keep dated lab notebooks and version code records. So capturing inventions as you go is particularly important, because it allows you to document the features and technical effects accurately. And if it's down and captured as you go along, then you reduce the chances of sort of missing something. You make sure everything's accurate, and also it just helps to sort of document any technical effects as you go along. Number 4 is compare against the research baseline. So by research baseline, we mean what would a skilled researcher have done without using your AI-driven methods? And then identify steps that your system replaces. So, what does it do above and beyond that baseline? What does it make possible, and what does it accelerate? One of the key points here is to document improvements. And I touched on this in the previous slide, but documenting improvements with respect to that baseline is beneficial. So improvements such as speed, accuracy, yield, efficiency, and sustainability. The reason this will help is because establishing and noting down these improvements over what's already known will help to support those the patentability criteria. So it will contribute towards the inventive step of your invention. Number 5 is, what did the AI cause us to do differently? So did it, for example, allow you to select a candidate material that wouldn't have been obvious previously from a very large search space? Did it enable you to prioritize experiments that usually a human would not actually reasonably choose to do? Did it recommend specific compositions that were then made and then physically made and tested? So it's what, not only what the AI model is doing, but what did it enable you to do differently? And so this is part of the point where identifying the practical output of the models will help to identify patentable features of the invention. Finally, the sixth point here is to do with disclosure of the invention. Before you publish or present any features of your research or your work, it's important to flag anything that worked different, that worked better, so the advantages, and also if you're planning to disclose, always speak to a patent attorney before disclosure. And another sort of quite useful question to ask is, could someone else implement this from our description? And that would answering that question, as well as speaking to a patent attorney, before you plan to disclose, will that can help to sort of help you to identify what would be safe to disclose and what you might want to wait before you file a patent application for. So the key point here is avoid disclosing the invention before filing a patent application towards that invention. The reason that we want to do that is because if you disclose the invention before filing a patent application, then that disclosure could potentially stop the patent application from progressing to grant, because it could effectively count as prior art against your own patent application, and thereby invalidate your patent. So yeah, speak to a patent attorney before disclosure, and there's something to consider as you're going through. So as a sort of brief summary of those 6 points, we're always looking for clear advantages, technical advantages, in the way that the process and the materials address a challenge. Now, sometimes patentable inventions can be missed because where there's a focus on producing results or producing research, sometimes people can often overlook the technical mechanisms that produce those results. And there are often patentable inventions within those technical mechanisms. And finally, the invention could be in different areas of what you're doing. So it could be in the materials themselves, in terms of the composition and structure of materials, the manufacturing processes, or the AI model itself. So I'm going to move on to a bit about strategic patent drafting for AI materials innovations. This is more relevant once you've decided that you've identified a patentable invention, you've decided that it could be the right thing to file a patent application, and that's in line with your business goals and your IP strategy. When it comes to drafting that patent application, there are some key things to think about. And I've noted 3 here. So the first one is technical character and inventive step. Now, where inventions involve software or mathematical methods, it's particularly important to specify and draft the application in a way that follows a problem solution approach and notes explicitly what the technical applications of the invention are. And particularly if it involves an AI model, then we want to include data to demonstrate unexpected improvements over what's conventionally known. The second point is sufficiency of disclosure. So when we draft a patent application, it's quite a detailed, lengthy technical document, and we have to include, by law, we have to include enough information in there, enough detail in there to enable a person skilled in the art in that particular technology field to reproduce it, to sort of put the invention into practice. And so that's what this second requirement means, sufficiency of disclosure. When we're talking about inventions in AI materials, so here are some of the things that we might need to include. So there's AI architecture, training data and validation protocols, details of implementation to demonstrate practical utility. So that comes back to practical applications of the invention. And specifying hyperparameters, activation functions, and optimization techniques. And those points are there to ensure reproducibility. So that would enable the skilled person to put the invention into practice. So that's a sort of level of detail that we might need to include as part of the detailed description when drafting a patent application. Now, after the detailed description is set out in the patent application, we include a set of claims, and the set of claims is effectively the legal part of the document which defines the scope of protection that we're pursuing. So when it comes to AI materials inventions, we typically want to include initial broad claims, which don't specify a specific use case, and then narrow to a specific use case, potentially narrow to a specific use case later in the patent process if we need to. So we always start off as broadly as we can. As the patent process goes along, we more often than not have to amend the claims, and then in the end we come to the result would be a sort of amended claim set which defines the scope of protection that you're then granted as part of your granted patent. In terms of what the claims cover, so you can have claims that are directed to material compositions, you can have claims that are directed to the AI model. So that comes down to what it would be commercially useful for you to protect. You can have hybrid claims, so you can have claims combining material composition claims as with AI architecture details. So that's also possible. And finally, the final point with claim drafting is that once you've defined your scope in claim 1, you can define fallback positions in dependent claims. And those fallback positions can be tied to specific applications or specific details within your sort of broadly defined invention of claim 1. I think Emily's going to pick up to talk about ownership of IP and some common pitfalls in ownership and collaboration.
Thanks, Monica. Yeah, so I'm gonna talk through some good question of who exactly owns a patent or an invention, and why that might make for some complex situations sometimes, and what you can do about that. So UK patent law, we're just going to assume for simplicity that everything's happening in the UK for what we're talking about here. The inventor of the invention, so that's the person who's actually sort of put in the creative inspiration to come up with the invention that's going to be claimed in the patent. That inventor, or possibly more than one person, more than one inventors, they will own the IP initially. They will own the right to get a patent application for that invention, unless they are employed by a company or a director of a company as another option. And the IP is created in the course of their employment. So, somebody's employed as a research scientist by a company. If they come up with an invention, then the company that is employing them is the person that actually is the first owner of that invention. So this situation can happen quite a lot. If a lot of people undertaking research, making inventions will be employed, and it will be their employing company that is the owner. If an employee makes an invention outside of their actual course of employment, so for example, if somebody is employed by a company with absolutely no expectations that their job role would involve inventing, and they happen to come up with an invention sort of in their own time, off their own back, the employer doesn't own the invention in that case. Even if somebody is employed with the expectation that they might invent something, and on the weekend they happen to come up with an invention that is related to their hobby that's got nothing to do with their work, then they would also personally own the invention that they've come up with in their own time outside of the course of invention. But we'll take a situation for now where somebody's an employee, they've come up with the invention in the course of their employment, and the employee is the default owner. So that's one way in which it might be somebody other than the inventor who owns the IP. The other way is by an assignment. So that's usually a written document that says, I, the inventor, hereby assign these rights to this company. Technically, an assignment doesn't have to be a written document. It can be like an oral agreement, but of course it's very difficult to prove in those situations. So you will almost always want to have a written formal assignment with a signature on it. That's what's going to be recognised by a patent office and by a court most easily. So I mentioned that you might have more than one inventor. So would be pretty common in collaborations or research teams, that there might be more than one person who's made a contribution to coming up with the devising of the inventive concept. That might be nice and simple if both of those inventors are employed by the same company, because then it's still just the company that owns the IP. It can get more complicated if those two people have different employers, and maybe are working together as part of a collaboration. In that situation, if they have genuinely together both come up with a concept, each of their employers will jointly be entitled to that invention, and you have a situation of joint ownership. That's perfectly possible. So you will see patent applications that are filed in the joint names of two people or two companies. It can make things a little bit more complex when it comes to handling the patents and the patent applications. So you'll need to make some choices about who pays for the patent applications in that situation. Do you split the cost? Does one party pay? For example, who's going to make decisions over what the claim scope is going to be, what countries you're going to go and get protection in? And there might be other questions around if you want to sell the IP in the future, if you want to license the IP in the future, you need the permission of the other party who's the co-owner to take some of these sorts of actions in the future. So if you're ever in a situation where you might be collaborating with another party and there's a chance that an invention is going to arise as part of that collaboration, it can be really helpful if you sort out before the collaboration begins what's going to happen to any IP that arises from it, who's going to own it, who's going to make these sorts of decisions and bear the costs. And you can reach all sorts of different agreements and arrangements between you according to what makes sense for the different companies involved. So that might mean owning the IP jointly and making some arrangement over making joint decisions and splitting the costs. But it would also be quite common to decide we've come up with it together, but one party is going to own the IP and the other party will assign their rights to it to this one party. They'll pay, they'll make the decisions, but the other party who's assigned away their rights will have an automatic royalty-free license. They'll be able to use the patent in whatever way they need to, perhaps within a certain technical field or something like that. And you can make quite bespoke agreements, and there's usually a good something that can easily be reached that makes sense for all the people involved. And the earlier you do that sort of thing, the better, because it means you're setting out the expectations right from the start, and you're not having to sort of retrospectively put something in place and fix things when one party might be holding leverage over the other party in these sorts of situations. Another important thing to keep in mind is that if you are commissioning some work, and an invention might arise as part of the commission that you're making, so you're paying somebody else to do some research and to come up with some ideas, the original owner of that invention will be the company that's been commissioned. So the inventor will be at that company, it will be that company that owns the IP, unless there is something specific in the contract that says that you, as the person commissioning this work, will own the IP. So it's important to make sure that if you are in that situation where you're commissioning something, that you have a clause in the agreement that makes it very, very clear that any IP that's arising as a result of this commission will be owned by you, and the company that's doing the work for you undertakes to assign that to you in the future. Different countries have slightly different laws around this. One slightly different handling comes in the US, whereas a employing company will automatically own the rights in the UK. In the US, the initial ownership still stays with the inventor, but they have an obligation to assign it to their employee. It's a sort of a subtle difference, but it can be quite important because it does involve sort of signatures and paperwork in the US in a way that it doesn't in the UK. So it's just something to be aware of. And if you are yourself an inventor, And it means that you might well see that if your patent application for your invention gets filed in the US, even if it's all owned by your employer or a university or something like that, you might be being asked to sign some paperwork in the US to say that you assign the rights to your employer and to sort of make various declarations that you have come up with this invention. And it's to do with that subtle sort of difference in ownership law in UK and the US. Next slide, Monica. So we just sort of thought we'd take you through a few common issues that can come up around ownership, which is also related to what we've just been talking about. So a very common one is some situation has arisen that involves lots of different parties, and somebody has just assumed that they will own the IP because it sort of makes sense to them. So, for example, we're collaborating with these people, but we think we brought this to the table. We've just assumed that we have the rights to the IP. And in practice, this can be more complex. The other sort of side of the agreement might have different opinions about things. One party might be funding all of the research and assume that they will own the IP because they're funding it, and actually that might not necessarily be true if that's not what's written in the agreement. So this sort of comes back to that advice to agree the IP ownership situation as early as you can before the work starts. Have a clear picture of what each company, each collaborator is bringing to the table. What IP do they already have and already own, so that there's no mistake over what it is that's new as a result of this collaboration. If it would be appropriate to have for any joint IP, then you want to agree with each other how you're going to handle licenses, agreements, how you're going to make decisions, and who's going to pay for things. So number 2, Monica's going to talk a bit more about this one because this is a sort of AI related invention specific.
Yeah. So second sort of potential pitfall is where the inventorship is unclear, where AI is involved. And so this comes down to who actually contributed to the inventive step and the technical the technical advantage of the feature and the invention. And this can be an issue where multiple researchers, multiple software tools, AI models, and data providers are involved. And so it's important to identify where the technical contribution came from. So an AI can't be an inventor. It has to be a person. And so it's important to track which people provided the technical contributions to a specific invention. One way of doing that is to track who actually defined the technical problem, who selected the constraints and different parameters, things like that, and who interpreted the outputs of the model. To track the human technical contributions. This also comes back to keeping dated records of each step, particularly decision making influenced by AI, and look at inventorship not only at the start of the project but also at the time of filing the patent application, because it's at that time where the invention is defined and not necessarily at the start of the project. So it's always good to revisit that when filing the application. So the point there is, AI tools are not inventors. It's always the people. The inventor has to be a person. And so, the key takeaway would be that it's the human technical contributions that are protected by the patents, and these can be guided by AI, or not guided by AI, but it always comes down to the human technical contributions and not the AI itself.
So number 3 is sort of adjacent to ownership. I suppose, which is the risks that there might be of losing control of your IP and losing the possibility of getting a patent application through disclosure. So Monica already touched on this on one of our sections under identifying potential patentable inventions, and I think probably a lot of people who've done a bit of work with patents or have a bit of knowledge will know that giving a conference presentation that explains what your research is and what you've come up with, that is a publication which can be cited against your patent and can invalidate the patent. But there are some disclosure risks that are particularly perhaps a bit more specific to AI, and in particular how your AI platform might be using the data that you're putting into it. So be mindful and cautious with open source data, shared data sets, as to exactly what is it that you're disclosing there. The data set itself might not be a problem, but what conclusions can other people draw from what you're putting out into the world? Monica, is there anything I thought worth throwing back to you to see if there's anything specific to talk about there in terms of open source and so on?
Yeah, I think well, yeah, I think practically that third point there, reviewing the AI platform and cloud tool terms for IP and data ownership, is a good tip to keep in mind. But other than that, I think it's covered.
Okay, back to you for searching and so on.
So we thought we would talk a bit about techniques around patent searching and patent landscaping. So these are techniques that you can use as part of your IP strategy to just sort of strengthen your position against competitors in the field. Patent searching is about a detailed, targeted investigation of patent documents. And so this can be used for one of two purposes. One, it could be used for novelty. So what that means is investigating patent documents that already exist to check whether the invention that you're thinking about patenting or certain features of that invention are novel, are in fact new over what's already been published and what's already in the public domain. A second use of patent searching is to establish your freedom to operate. And what that means is establishing whether somebody else has already filed and published a patent application in your field or an overlapping field, affecting whether or not you're free to operate in your chosen field, in your chosen invention. And so patent searching, you're typically focusing on specific questions about your competitors. So for example, what patents does company X have? Has something like our invention already been patented? And then in terms of freedom to operate, are there any patents that might block our product and affect our freedom to operate? So in practice, patent searching will involve searching for specific keywords, specific competitors, and particular technologies, as well as novelty checks and freedom to operate investigations. We can use patent searching as a tool to monitor competitors, if that's something that would be that. So at this, depending on which stage you're at, that would be useful, and pre-filing diligence as well before considering filing a patent application or drafting an application. It's doing some early checks to sort of see, just check what your position is in comparison to your competitors. So all in all, patent searching can be thought of as identifying the most relevant patent documents within a large body of prior art. Those Yeah, it can include published patent applications that have been published anywhere in the world. So onto patent landscaping. Patent landscaping is quite different in that it involves a broader analysis of patent activity across a certain space, certain technology space. So instead of looking at individual patent documents, it looks at patterns, trends, and positioning within that technology space. So instead of searching for specific keywords and performing a detailed search for patent documents, it's more about analysis and categorizing patents, analyzing trends, and then mapping key competitors, key players, and white space. So patent landscaping can be used in terms of as part of your developing your R&D strategy. It can also be used to identify opportunities, white space opportunities, support investment, as well as developing sort of a long-term IP roadmap. And so rather than understanding the specific patent documents that are out there, which is what patent searching does, patent landscaping is more about understanding the shape of the landscape before choosing where to build, which inventions to focus on, and where to progress. Just a brief sort of comparison here of patent searching and patent landscaping. So where patent searching is narrow focus, patent landscaping is broad. The goal of patent searching is to answer a specific question, look at specific documents, whereas patent landscaping is much broader. It's to understanding an entire technological field. Patent searching is often used in the short term to guide next steps in your IP strategy, whereas patent landscaping is used more for long term and feeds into your R&D strategy. The output of patent searching, often a list of relevant patents, which we would then review and analyze, whereas patent landscaping will come up with trends and insight as outputs. And finally, the typical user for patent searching is often used for R&D and founders of companies to guide next steps, whereas patent landscaping is often used by more broadly by leadership and investors, for example. In practice, companies usually use both, and they one might guide the other. So patent searching could potentially come first and then feed into patent landscaping, and then landscaping could highlight where more deeper patent searching might be needed. The reason these techniques are useful is because together they can help to guide patent drafting, to guide R&D strategy and IP strategy, and also position yourself better in view of your competitors and competitor activity. In AI materials, especially, an important part of patent searching, an important reason why you would perform patent searching, is to help to avoid known risks, while patent landscaping helps you discover where innovation is still open. So those white space opportunities that you might want to explore more. Emily's going to pick up for some practical IP tips.
So we're going to talk through a few tips for particularly for early stage companies who might be sort of just starting out on their journey and are probably therefore under certain cost constraints when it comes to IP. There's an awful lot you can do, there's an awful lot you can protect, but it all costs money. And the reality is that a lot of companies or researchers at early stage just aren't in a position to spend money on things. So these are a few tips and things you can keep in mind and do without necessarily having to put a lot of investment in, or how to make the most of some of the opportunities that are out there. So the first thing would be have a clear idea of the purpose IP is going to have in your business. This is something that's good, even if you're not actually going to be filing patent applications. Making a proactive, positive decision to do that and still being aware of the IP that you have is really important. IP in all its forms, whether that's a patent or something else, is attractive to investors. Knowing what your IP is and what you're doing with it is a good sign to potential investors. Registered IP, patents, registered trademarks, they give you particularly good control of your innovation, so the ability to stop other people from doing the same thing as you, but also just controlling collaborations and things like this. So this is a core reason why you might want to have registered IP. And IP can also be licensed to others to generate revenue streams, and some commercial business models will be built entirely on a licensing model where they will sort of be coming up with innovations and license them out to others to do the manufacturing and so on. So understanding where you're going to be using IP, where you're going to be getting use from it, and making your IP strategy align with that is a helpful early step for you. And of course, revisiting that as the company evolves and as the inventions evolve as well. So sort of following on from this, capturing and recording your IP as it's generated is important. Monica's already touched on this in some of the earlier sections. We would always recommend a good strategy is to ensure that you have somebody in your company or your research whose responsibility it is to record the IP and record the decisions that you're making about it. So as one clear person with that responsibility, and something as simple as an Excel spreadsheet to track what it is that you're generating and what you're deciding to do with it can be really useful. So just recording what the innovation is, coming back to that technical solution to a technical problem, just record what the problem is and outline what the solution is, who came up with the solution and when did they come up with it, and then think about what you're going to do with that IP. You might keep it secret and not do anything more with it than that. You might decide you do want to file a patent application, and you might think about when you want to do that. Maybe that's, we want to develop this bit further before we start thinking about a patent application, or it might be this is really important, we want to go ahead and get it filed right away. But it's a really good idea just to document briefly what the decision is that you're making, and if necessary, what's the follow-up action going to be? Are you going to revisit this in 6 months' time? Are you going to go and talk to a patent attorney within the next month about this? It can often be good to have a sort of regular decision point. So maybe once a quarter, you sit down, look at the IP, make sure you're up to date, and you've made decisions on everything that needs decisions. So number 3, mindful disclosures. This comes back to something we've already been talking about, which is just taking care not to disclose information before you filed a patent application. Another reason why it's useful to note what it is you're going to do with IP, whether you're going to file a patent application or not, whether you're going to wait, because you can make sure that any disclosures you do want to make are taken account of, and if you need to file something before a disclosure, you get it filed. Once you have got the patent application filed, in principle, you can disclose that invention, you could make a publication and so on, but you do have to be quite careful about making sure that you don't disclose anything beyond what you've put in that first patent application. So maybe your research has carried on and you've made improvements and you've made developments, and those improvements and developments weren't included in that first patent application that you filed. And this is where a little bit of danger can come in, because you can feel like you're safe and you can disclose things, and actually you're going beyond what you've put in that patent application. Worth continuously reviewing as your research continues. Once the patent application has been filed, is there something new here? Do I need to just talk to my patent attorney and make sure this part of it is captured as well? Do we need to do anything else? Do we need to make another filing, and so on? If you find that you do need to discuss an invention before a patent application has been filed, and you do plan to file an application to protect it, maybe you need to discuss it with a potential investor. Maybe you want to talk to a potential supplier or a partner about it. Just make sure there's a non-disclosure agreement in place. It can be a really simple agreement. It doesn't need to be really complicated. Literally just a few lines is all that's needed to have a confidentiality clearly in place. And if you don't have access to a sort of simple non-disclosure agreement, we can provide a template that you can use. And then the fourth point would be to get some IP advice as early as you can once you do start having innovations coming up. So most patent attorneys will offer you half an hour, maybe an hour of free time for initial consultation, and you don't be sort of scared to approach patent attorneys and ask if they will give you half an hour to talk through your invention and what you should do about it. And if you can go to that an initial meeting with as much knowledge as possible, which hopefully you have at least from these sessions and perhaps from other resources as well, you'll be in a position to make the most out of those sorts of half-hour meetings. If you've sort of got a good knowledge of what patentable invention is, roughly what the process looks like for patents, then you won't need to talk to them so much about that, and you'll be able to focus your hopefully bit of free time a bit more on what your invention is, what you should be doing, and get that sort of really useful advice. And the more that you can tell them about what your long-term plans are, how you want to use the IP within the business and for your invention, the more useful advice you'll be able to get out of them in a session like that. So the next slide is a brief mention of some other ways that patents can be useful financially to companies, which is through patent box. So this is comes into use at the point where you are actually profit generating, because it allows companies with patented inventions to apply a lower rate of corporation tax to the profits that they earn from those patented inventions. So this is whether you've got a UK patent or a European patent that designates the UK within it, as long as you've got some kind of patent protection in the UK, doesn't actually matter how broad or narrow that patent protection is, as long as you've got a product or a method or a process that is covered by a patent, then it will be eligible for some amount of reduction in the corporation tax. So we do sometimes see companies getting patents specifically for the purposes of applying patent box to them. R&D tax credits is another sort of related tax benefit that you can have through R&D that you're doing as well. And I think that is probably it, other than that's Monica.
Yeah. So we can help with various stages of planning your IP strategy and different stages of the IP process. So these are some of the things that we can help with at Keltie. One thing we haven't talked too much about is IP audits. So this is an initiative which helps you to establish what IP you already have, and also start to develop a strategy for protecting aspects of your technology and aligning that to your commercial objective. So we can help with protecting the IP. So we regularly draft and file patent applications, file registered designs and trademarks as well. Any sort of advice or questions around patent searching or patent landscaping, IP clearance, IP strategy, that sort of thing, we could help with that as well. And finally, the IP process. So it can be, particularly the patent process, can be quite complicated. So we often help companies to navigate each stage of that, and the requirements at each stage, from preparing and filing the patent application all the way through to grant of that patent application. So a brief summary slide. So we did a sort of brief recap of webinar 1. We talked about identifying patentable inventions. So hopefully that gave you some practical tips, practical questions to ask as you go along in your research. Things like capturing data and results as you go along, thinking about the technical problem that's being solved and the technical solution that's being formulated to address those problems. Looking at and exploring different aspects of the technology, including materials, processes, as well as the AI models. We then talked about some strategic patent drafting for inventions in AI-driven materials, where three sort of important points were considering the technical character and inventive step. So the practical technical implementation of your invention, disclosing that invention in the patent application sufficiently, and finally some tips on drafting the claims. We then covered some issues around IP ownership and collaboration, and talked through patent searching and patent landscaping and how those techniques can be used. Then we covered some practical IP tips, so establishing the purpose of IP, capturing and recording data as you go along, being mindful about disclosures and seeking advice for that, and finally looking for IP advice early in your journey to help guide decisions later down the line. And finally, we a few things that we can help with at Keltie, including protecting the IP and preparing and filing those applications for IP rights, IP clearance techniques, and developing IP strategy and navigating through the IP process. And with that, I'd like to thank everyone for listening and for your time today. Please feel free to connect with us on LinkedIn. We've got our profiles are up there, and email us. We would be happy to book you in for a sort of free half-an-hour chat to kind of answer any other questions that you have, and we can talk about any issues that you're facing and discuss IP strategy within that as well.